Good evening. As brought out, this has been 75 years of India's constitution. One of the legal luminaries, Dr. Madhav Menon, who happened to be heading the NLU Bangalore, in a talk a few decades back, stated that what defines India is its constitution, because we share our geography, history, and culture with our neighbors. So, what actually defines it is our constitution. And I think there is no doubt that our constitution is our pride. And if you actually go through this book, which Dr. Ram Madhav has written, you will find it. The details of the efforts taken by the founding fathers of India to come up with this wonderful piece of which governs our destiny, which has framed the way we have shaped. And in fact, the efforts that were taken, it is probably the longest written constitution in the world. An amount of efforts that 299 members of the Constituent Assembly took to frame this constitution. Now, today we'll be discussing about this book. One of our discussants, Mr. Shekhar Gupta, is expected to join us shortly. I'll now request Dr. Ram Madhav to kindly speak about the book in about 15 minutes, though I know this book is a treasure trove of information. May be difficult, but we'll request for the sake of discussions that he restricts himself to 15 minutes, and then we'll have other discussions.
Thank you, Alokji. Namaskar to everybody. I want to be very brief. Firstly, because authors always feel like talking more and more about their book. But if I talk for too long, then you won't feel the need for buying the book. So my publisher will be unhappy. So I will be very brief for one important reason. But the more important reason is these days it is very risky to talk too much about the Constitution. Media is there. Any sentence can be interpreted in any manner. So keeping that risk in mind, I will be very brief. Ideally, I would probably request the panelists also that it's not the book which is really important. Important is that theme, which Prime Minister Modi declared as a year-long theme for all of us. Hamara Samvidhan, Hamara Swabhiman. This year happens to be the 75th year of our constitution. So that spirit is what is more important for us to probably discuss. How is it the pride of the nation? What has gone into its making, and how has it contributed to our national life in the last more than 7 decades? Probably that will be a more appropriate thing to do rather than only focusing on the book. Although this book essentially deals with those 3-4 parts about our constitution. First is the general opinion about our constitution is that it was drafted through a course of 35 months, starting sometime in 1946 and ending in November 1949. As Alokji mentioned, by 299 members, spending hundreds of hours of midnight soil, they drafted this constitution. But the fact is that the struggle for this constitution began at least 25 to 30 years before the actual commencement of the Constituent Assembly. If you all read history, the first Government of India Act was promulgated in 1858. At that time, there was no opposition to it. It was an act promulgated by the British Parliament for the sake of governing India, but nobody was there to oppose it in 1858. The second time the act promulgated was in 1919, Montagu-Chelmsford reforms. At that time, there was a movement led by Congress. Gandhi was a new entrant, new leader. It helped Gandhi to become the leader of the Congress movement for various reasons. Tilak left for London and so many things happened. Gandhi gave a call for non-cooperation against this Government of India Act of 1919. The third act was in 1935, Government of India Act 1935, by which time, looking at the popular movement and the demands of the leaders at the round table conferences and all, several aspects of the demands of the Indian independence movement were sought to be incorporated. Yet, the Congress was not convinced. Congress called it a slave constitution. The principal demand of Congress was that it is going to be the Constitution of India and we should draft it, not you, sitting in London. Finally, in 1946, the cabinet mission came and they agreed that, okay, you are the makers of your constitution, you build your constitution. There was a process. In between, in 1927, Simon Commission came. Simon Commission came with the objective of, suggesting constitutional reforms for India. Aye, Shekharji, please. Even at that time, the Congress opposition was that who are you to tell us what reforms we want in India? So then Birkenhead was the Secretary of State for India. So Birkenhead says, you are saying that you want to make your own constitution. If you are so intelligent, why don't you show us a draft? Congress takes it as a challenge. And Congress appoints Nehru Committee. Nehru Committee means Motilal Nehru-led committee in which there were stalwarts, all those senior leaders were members of that committee. They actually come out with a constitution, draft constitution in 1928. It had 22 sections, 88 articles. Nehru report was presented to the British that this is our proposal for the constitution, but then British never wanted really to accept the draft prepared by Indians. So they say, no, you build consensus around it first. Obviously, as long as Muslim League was there, there was no possibility of any consensus. So they used that excuse to reject the constitution. Anyway, cutting the story short, we had this Constituent Assembly in 46, which ended in November 1949. It came out with a beautiful constitution. Last 75 years, this constitution has served our country so well. It gave us that spirit of one people, one country, one nation, one people. That spirit was the greatest contribution of this constitution. But my book also deals with, besides of course the process of making the constitution, it also deals with the journey of last 7 decades. Very interestingly, in the Constituent Assembly, several important issues were discussed but could not be, there was no consensus to incorporate those things in the constitution. For example, there was a lot of discussion about Hindu Code Bill. Ambedkar was very, very insistent that we should incorporate Hindu Code Bill into the constitution, into the draft constitution itself. But there was no constitution. On a lighter note, in fact, Rajendra Babu says, my wife would not allow me to step into the house again if I accept it now in the house. He was the chairman of the Constituent Assembly. On a lighter note, it's another matter. As president, he himself signed on the Hindu Code Bill in 1956. Then similarly, fundamental duties. It was the very dear topic to leaders like Gandhi. There was a lot of debate over fundamental duties, but finally decided not to include it in the constitution. After a lot of debate, directive principles was added, but not fundamental duties. Third was the rural, decentralization Panchayat Raj system. Again, a lot of discussion happens in the Constituent Assembly. So much so that, leaders like Hanumantayya from South, from erstwhile Madras presidency, Hanumantayya stands up in the Constituent Assembly and says, where is Gandhi in this constitution, he asks. So much debate happened, but they decide not to have Panchayat Raj system because both Ambedkar and Nehru were of the view that no, we should not give too much importance to villages because India has to develop, it's not the way to go about. Then centralized planning. There was again something that Gandhi always abhorred. Gandhi said India should be a decentralized society, decentralized country. But the whole emphasis there was centralized planning. Then we all know about Mahalanobis and Nehru's friendship. A statistician becomes the planner of our 5-year plans and all that. On Article 370 also a lot of debate happens. In fact, many members, including communist members like Hasrat Mohani from United Provinces, they stand up and ask the simple question to Nehru and others, that you are giving this so-called special status to one state, then why not to Awadh? Why not to Vadodara? Why not to all others? You give that special status to everybody. Why only giving to Kashmir? So much opposition. Still, that article finds place in the Constitution. So many issues were very hotly debated, but could not be fully implemented in the first Constitution. But if you look at the journey, over the course of next few decades, all these things became a reality. They all have become like, Hindu Code Bill became a reality in 1956. Then, आगे जाकर fundamental duties. Very, very surprisingly, Indira Gandhi during emergency, she robbed the fundamental rights of everybody of the country and then declared fundamental duties for people through Article 51A. Similarly, decentralized system has been implemented during Narasimha Raoji's regime through 73rd and 74th Amendment. So some of those things which were discussed in the Constituent Assembly could not be incorporated in the Constitution, were subsequently incorporated in the course of last 6-7 decades. I also touch upon the misuse of the Constitution. I mention only 3 occasions, but there can be more occasions. But 3 glaring occasions, the glaring instances for one was the misuse of Article 356. Began, in fact, the first scrapping of any elected government happened in 1953. Just 1 year after the first general election, using Article 356. But that was partly legitimate. The government in Punjab at that time was a coalition government not running at all, so there was a reason to do it. But 1959, the scrapping of Namboodirippa's government in Kerala was a big crime, biggest misuse of Article 356 first. That is one instance. Second was about emergency. Using the emergency powers provided in the Constitution, emergency was imposed on the country, and a draconian rule was imposed on the country for almost 21-22 months. And finally, Shabano case in 1986 was another example of how the Constitution, the very articles, were sought to be misused. So there are some of these things that you will find in this small book. It's not a big book, small book. But I end with only one important submission, that it's not the letter of the Constitution which is the most important thing. The spirit is what is important. What many Westerners call as constitutional morality. Meaning understanding the spirit of the Constitution and developing that kind of a constitutional morality is what is important. Both Ambedkar and Dr. Rajendra Prasad, as leaders of the Constituent Assembly, actually appealed to this particular element. Constitution is just a document. What is needed is constitutional morality. People have to develop that morality of following the Constitution, not just in letter, but in spirit. When we celebrate 75 years of this Constitution, what is of utmost importance is to develop that constitutional morality. With that appeal, I ended the book. This has certain annexures also, which give you some important speeches that were made right at the time of the Constitution making and until very recently. A small book, please do read and enjoy, but the spirit I mentioned, the Constitution, its spirit, that spirit should be the pride of all of us. Thank you.
Thank you, Ram Madhav ji. Constitutional morality is the key, and I think that takes me to quote from this book, Dr. Rajendra Prasad's sane advice, where he said, "Our Constitution has provisions in it which appears to some to be objectionable from one point or another. If the people who are elected are capable and men of character and integrity, they would be able to make the best even of a defective constitution. If they are lacking in these, the constitution cannot help the country." So that was the advice, and I think that is where constitutional morality is the key. Now I'll request our first speaker, Shri Shekhar Gupta ji, who needs no introduction. a very renowned journalist. He is presently the editor-in-chief and the founder of ThePrint. He was earlier with Indian Express. All of us have known him for decades. We'll request him to take 10 to 15 minutes and delve on the book.
You want me to speak from here? Or
wherever. It's
all right.
your choice.
All right. I can speak from there. Somebody time me. So what I'm going to do is, Ram has done a very good job of talking about this book. He calls it a slim book, somewhat self-deprecatingly, but the fact is that one of the challenges with the Constitution is that it's not such a slim document, right? People carry some version of it in the pocket, or comedians can also flaunt it. In spirit, that's a good point, that, the Constitution protects us, but the problem with our Constitution is that it's very long-winded. Also, over time, there have been so many amendments that Constitution has become a little bit like the Income Tax Act, where you know that some law or some section applies to something, and I think, as with Income Tax Act, which is now being, basically the new form is just a rewrite, leaving out a lot of old stuff and summarizing it. What in old days in UPSC used to be called Pressy writing. I don't know if it still happens or not. So Constitution is long. Constitution is complex. Constitution is not user-friendly. User-friendly, when I say, that's for the common citizen to try and understand it. It's very user-friendly when it comes to protecting our freedoms and keeping order in the country. So as he says in the book, the Constitution has given us a sense of being a people. That what is it that unites India? So right now you can very simply say the Constitution unites India. So you might be from the most distant part, the most distinct part of the country. You might be from an ethnicity in a distinct part of the country with just 3 lakh, 3.5 lakh people. Look at Sikkim, for example. Or see Mizoram. Mizoram is now just about 1 million people, one ethnicity, right? But how are you Indians? Because the Constitution makes me a part of India. The Constitution also gives me a dispensation to address my anxieties, my uniqueness, etc., etc. And I have power in my own domain. So, in fact, there is something that I write often enough. Often enough means you're often short of ideas. I have to write a column every week. And when you are short of ideas, you recycle an old idea, right? Don't tell anybody that secret. So one of the ideas that I revisit often, and that is because something happens that justifies the use of that idea again. That is the way the Indian state has handled insurgencies in the country, particularly in the Northeast. And from that, we developed the idea of a bell curve of Indian insurgency. That insurgencies begin, then violence on the ground, insurgents become strong, they become strong. The state response becomes stronger, then insurgents become even stronger. Casualties on the state side or civilian side go up. Then at one point, it peaks. It peaks at a point when insurgents know that this Indian state will never give up. So the basic thing is, the basic argument I make is that this is a very tough state, irrespective of who's in power. When it comes to self-preservation, the Indian state is among the strongest in the world, if not the strongest, right? Even minority governments, even Chandrasekhar's government with 40 MPs, which we used to call government of Ali Baba or Chalis Chor, right? Even a government like that was totally unforgiving with anybody challenging India's sovereignty. So what happens when you reach that point on the bell curve? Then insurgents know whatever the number in terms of bodies on the ground, these guys will not give up. So I will not get sovereignty. At which point the negotiators move in. I saw this, I wasn't there to cover it, I was then in school, but if I read up on the history of Naga insurgencies, in the 60s, it's Sarvodaya and Jayaprakash Narayan, Vinoba Bhave, all of the others moved in to try and bring about some kind of peace and rapprochement. That was a time when Naga insurgents had more than 10,000 AK-47 rifles. Indian army did not have even one. right? Even one, right? And at that point, they decided not to declare sovereignty because people were reaching out to them and saying, listen, you want sovereignty? You've been to Tibet? Do you see sovereignty there? You want to protect your Christianity? You've seen Buddhism in Tibet. You really want it? But in this place, there is a constitution under which we can create something for you. And see what happened with Naga Peace Accord of 1975, which pretty much brought peace because the bigger tribes had come over ground. Some dispensation was created for Nagaland under the same constitution, under Article 371. So this constitution is something under which you can, it's a big umbrella. If Indian society is so diverse and so distant and it could be so divided, right? People could divide us to rule us. And this is the umbrella which keeps it all together. So imperfect as it is, every published document is imperfect. And that's a point on which I will come in a moment because Ram talks about it. But it is as perfect, it's been as good as any document has been for a country like India. If you go back to the history of decolonization since then, most new countries, diverse countries that came into being have broken up. Next door, Pakistan has broken up, Soviet Union broke up in so many, Yugoslavia broke up in so many that if you ask me, if I were to appear in UPSC and you ask me how many countries did Yugoslavia broke up in, I will not be able, I will flunk it. In fact, I figured just the other day that, was it Italy or France? One of those failed to make the qualifiers for the Football World Cup because they lost to North Macedonia. It's then I figured that North Macedonia is a sovereign country with a team of its own. But India has stayed intact. In fact, not only has India stayed intact, every decade India has become stronger. And if that has happened, one of the reasons also is the flexibility within this constitution. Now, Ram talks a great deal about the damage that was done to the constitution in the Congress era. I would say whenever you have a government with a large majority, the temptation to play with the constitution will be great, right? Majorities would think, look, I have the majority, where's the problem, right? Why can't I not do this? I have the majority, people have voted for me just because of this constitution. Then I will go to court, then court will stop me. So every majority gets tempted. Congress party did it, to use Trump's English, bigly, right? 53 was one thing, but 59 was the other thing. But it went on after that. See what happened after 1967. Mrs. Gandhi lost state elections in so many states. And Sanyukt Vidhayak Dal state governments came in. We know what happened to each one of those, and that's how this business of non-simultaneous elections started. That is where it's rooted. So that is one. The other thing also is we know the emergency, of course. That's one highlight. But Ram talks about the Shah Bano law, that Rajiv Gandhi amended the law. Again, that was a violation of the spirit of the constitution. And the fact is that one act, when Rajiv Gandhi got elected with 413 or whatever seats, there is nothing, I'm saying this metaphorically, I didn't have any children then, but I'm saying this metaphorically. Rajiv Gandhi could not say, I did have one child who was an infant then, but so I'm just using this as a metaphorical example. Rajiv Gandhi could not say anything that would not bring tears to my mother's eyes, right? Look at this boy. He's so fantastic, right? At that point, Arun Shourie once got irritated with his mother. She said, "Itna sharif ladka hai, itna pareshan karti ho." So he said, "Are you looking for a prime minister or son-in-law?" Right? So nothing Rajiv Gandhi would say would not bring tears to my mother's eyes. Within 1.5 years, nothing Rajiv Gandhi would say would not make my children laugh. How did that dramatic turn come? That dramatic turn come because of what he did with the Shah Bano case. That is probably the biggest blunder and an immoral blunder made in Indian political history. Because that one blunder ensured Congress party has never got a majority since then, right? Because one thing leads to another. Because Shah Bano then led to something else, then the ban on Rushdie's book, then everybody said, but now Muslims have got, the Hindus have got angry, then you allowed the Shilanyas, then you said, okay, pehle tala khol diya, phir Shilanyas, then he launched the election campaign from Ayodhya promising Ram Rajya. So everything had got messed up. Why? Because in one case, you made one big immoral move. And that was to violate the spirit of the Constitution. So Constitution is also a book that I don't know what holy books do, what power do holy books have, but Constitution has that power. If you mess with it, it will punish you severely. That's one. So on this one, I will leave a question for you, Ram, which is many argue that there is a grave threat to the Constitution, as Ambedkar imagined it. Dalits fear reservation can be revoked. Muslims fear special laws will be retracted. So beyond whataboutery of the Congress party did this, of which I have explained, given you a few examples, what else can be done to reassure the nation? So I leave that question for you. Then efforts have been made to try and modernize, change, make the Constitution more relevant. Vajpayee, Ram writes about this, set up a commission to which I was also invited to speak at one of the hearings. Mr. Advani was putting a great deal of heart behind it. But then again, question always was, if you do this, there were many ideas then, fixed term for parliaments and legislatures, abolition of the no confidence motion, introduction of the constructive no confidence motion. But the basic structure argument always came in. Now, 7 decades later, again, Ram, does that argument need to be revisited? When you speak of revisiting, because you mention, you talk about revisiting some of these arguments, what do you have in mind? What is the problem that you're trying to fix? Or are you finding a solution for a problem that doesn't exist or is imagined? Or are you saying that basic structure is the problem that it is? You mentioned about fundamental duties. The fact is, when Mrs. Gandhi made those toxic amendments in the Constitution, in the 6th year of her parliament, that was an illegitimate parliament because she had extended the term of that parliament. The government that came in, Janata government, it repealed everything else. But some of the things were not repealed. And one of those things was fundamental duties. And it's fundamental duties even now are, in fact, we can see that the establishment is privileging fundamental duties. On the 150th anniversary, was it, of Mahatma Gandhi, the article Prime Minister wrote at the New York Times talked about fundamental duties. Rajpath has been renamed Kartavya Path. So is there now a larger cross-party understanding, because this was left unrepealed? There was an opportunity to repeal it wholesale. So is this contribution by Mrs. Gandhi during the emergency through an illegitimate parliament in its 6th year, did it have so much juice, so much oomph, or even these days I'm afraid of using the expression, so much sex appeal, right, that nobody has not only not removed it, but also not questioned it. And then there are other issues. I will not take other speakers' time. There is the question of NJEC versus the collegium. So my question, has the time come to revisit the collegium system? Good timing, isn't it? Is that another, or you think that's another form of Khan market consensus for you? That's the collegium system. And then we can go on and on. And finally, the philosophical point. You mention in the book that Buddhist Bhikshu Sanghas and Vedic Sabhas and Samitis were organized on the basis of democracy. I have read Arvind Kejriwal's Swaraj, where he talks about the kingdom of Vaishali, where when Magad decided to attack them, he said, everybody called the Gram Sabha and said, you vote, and that's the kind of democracy I will have. To which I did then write that, look, Magad came to attack them. People of Vaishali kept on arguing whether or not to raise an army, and they got wiped out. And that was actually the metaphor that was used for Pokhran 1. So what was the code for Pokhran 1? The code for Pokhran 1 was Buddha is smiling. So why was Buddha smiling? Because the belief is, the story is that when Magad devastated Vaishali, then somebody went and told Buddha. And Buddha frowned. And the Buddha's message was that if you want peace, you have to have strength. Because strength is your deterrent to war, and strength will ensure peace. So Buddha frowned, Buddha was unhappy. Now, because India had the nuclear option, Buddha was smiling. So that's where it comes from. So sometimes a lot of this basic level democracy can also become problematic. So is there a perfect democracy? No. Is there a perfect constitution? Ask Donald Trump, right? That's a short constitution, right? A long constitution by itself is not a problem. America is the shortest one, and see what Trump is doing with it. Or Trump ko dekh ke, because he mentions it that this is the era of the rise of authoritarianism. See what Erdogan is doing, because every dictator in the world, particularly every elected dictator, now looks at Trump and says, if this guy can defy his judicial orders in America, why can't I do it? So preemptively, uska election is in 2028. Already he's arrested the opposition's candidate against him. Already. And he's filed cases against him that can keep him in jail forever. So everybody has a constitution, but ultimately it's the intention of those who follow the constitution, and second, the strength of your institutions to not fight for it, but to work according to it, and to make sure, because institutions are the umpires in a democracy.
Thank you, Shekharji. I'll now request Shri Vikramjit Banerjee, Additional Solicitor General of India, to make his comments.
Thank you. It's a difficult task to bring up after Mr. Gupta, but I'll try. Respected Ramji, Alokji, Mr. Gupta, Swapan, it's a great honor to be invited to speak on the wonderful book which Ramji has written, which I think is very interesting. And I'll flag why it is very interesting according to me. And I was discussing this with Swapan before we came up on stage. I think the most important part of this book is the book contextualizes the Constitution in terms of constitutional history. There is an increasing line of thought, and which runs from the school where I studied law, which is the National Law School in Bangalore, that the Constitution is a text in itself. It was like Moses went up the mountain and came back with the Constitution. So it's almost like tabula rasa. So the Constitution comes and your history is wiped out before that. So every text, every contextual situation, problem in India has to be interpreted in terms of this wonderful text which has come to you. And this text came, for the want of, we use a legal word, dehorse the context, without the context. So I think this book is wonderful because there are two things it does, and then I'll speak whatever I have to. One, it contextualizes history in terms of the context. So it says, and it's something which needs to be said a number of times, that the Constitution did not arise based on those 5 days or whatever, 1.5 years of debates. But it arose in a specific context. The context is of the struggle for a constitution, struggle for self-government, Swaraj, if you call it. And it comes into another context which needs saying. After 1857, the Indian elites clearly decided that they wanted a modern state. Anyone who wants to check, the rebellion of the princes finished after 1857. The Indian politics clearly took a modernist turn after 1857. People across the board came to a conclusion that the princes are over, nothing's going to happen, we can't go back. As a result, there was a conscious decision of how to create a modern state. Now, the entire struggle is how do you create a modern state in this very old ancient country? And that is the entire struggle. We ask for representation and so on and so forth. And it's slowly, and there is a lot of history how Indian people get represented in the civil service, in the judiciary, which I think are all very, very important areas of struggle and which goes into constitution making. And so it's not only about representation in the legislature. All this gets incorporated in a slow process, but it's very, very clear. So it is very important that this is contextualized, because there's an attempt to wash away as if we are a new country. We are not, there are wonderful things about America, but we are not the United States of America. Our history is 5,000 years old. I think sometimes the Supreme Court makes the mistake of thinking that it is extremely new. And that is my issue with, this I'll differ from what Ramji said about constitutional morality. Though I know Baba Saheb Ambedkar spoke about constitutional morality in a different context, but the Supreme Court sort of interprets constitutional morality is that it takes out a morality which arises from the constitution through which it wants to change society. I have differences with it, because I think that constitutional morality which the Honorable Supreme Court speaks about arises from a context of people like us. And the greatest problem is to think that people like us constitute the rest of India is the entire dichotomy of the Supreme Court. I think if anyone who reads or understands the undercurrents which go under Sabrimala, and the case which when it finally comes up to the Supreme Court is exactly this. On one side you have constitutional morality, and on the other side you have public morality. So originally the entire attempt was to change morality by instituting constitutional morality. And constitutional morality is a constitutional morality which arises from the Constitution, interpreted by the Supreme Court as what should be the morality, and which completely differed from the way people perceived that issue. And I think this is the dichotomy which is going to increase, because on one side you are going to have this very people like us interpretation of the Constitution, which does not work on the ground. The other aspect which requires telling is the Constitution is not only the Constitution. Because the Constitution is not only the text, Constitution is also how it's being worked out. Some of the most important parts of the Constitution, including the collegium, is by judge-made law. Some of them, I think the scheduled caste order, which is extremely important, is by an order. I think the original reservation system of the other backward classes is by a departmental order of the Department of Personnel and Training. There are large parts of the Constitution which are fundamental as to how we govern this country, which is not part of the Constitution. And most importantly, I think the judiciary especially has been confronted, and this requires telling, by using a Western, for the want of a better word, I'm using a shortcut for that, a westernized constitution or a constitution written in Western terms, and let's be all very clear, it was written in Western terms, and trying to implement it in a society which is completely very, very different. So what it does is another very interesting thing. It says this is what the Western term is, and we are going to make it an Indian term. For example, when you talk secular, I can take you through every one of them, but when you talk about secularism, you don't mean secularism. You mean ekam sad vipra vahuda vadanti. When you talk socialism, you don't actually mean socialism. You mean Sarvodaya. This is express words of the Constitution. When you talk about Article 21, which is your right to life, you say it's not actually right to life, but right to have a life which is not mere animal existence, words of the Supreme Court, which basically says that everything, right to a road, right to clean water, right to clean air, everything comes into the Constitution. This is anybody outside India ever conceptualizes right to life to be beyond simply what is there in the Constitution, that you cannot be arrested without due process of law, it is inconceivable. But the Indian judiciary was actually forced to confront the question is, what is the right to life? And in Indian context, it sort of perceived the right to life is much more than that. So that's completely an Indian context which it channelizes through Article 21. Article 32, which is right to approach the Supreme Court. Now it's very clear who can approach, who cannot approach in the text of the Constitution. But what it does, the Indian Supreme Court does, it says Article 32 means anybody can write to it. Anybody can approach the king for justice. You can write on a postcard and you can come. And I can take you by throughout provisions of the Constitution. There are large parts of the Constitution which the Supreme Court has actually Indianized it in application. So even if there are large parts of the Constitution which could have come from a Western sort of orientation, because that's where, for the want of a better word, because that was a very conscious choice. There was very clear discussion in which Ramji says in his book that the Aund experiment was then doing the rounds, but the consensus was, we don't want to hear. There was like across the board consensus. Though people screamed about it, there was across the board consensus that we don't want to go down that road because you wanted a modern state. Because you want, that great walls, great neighbours, you wanted a modern state. So irrespective of all that, you created a modern state. But to actually apply it and work it today, you had to Indianize it. So according to me, these two stories, one which Ramji speaks about and which I think is extremely important and worth saying, that arises from a struggle. The Constitution does not arrive as straight out from heaven. It does arise out of a great struggle. And two, which Ramji indicates, but it does not carry forward, I think this Indianization of the Constitution, naturally it had to happen, because whatever the framing of the Constitution is, when you actually work it, you work it amongst the Indian people, had to be, is Indian. And so in many ways, the Constitution or the governing system which we see today, and it's not only the text of the Constitution, but also the laws, the question of reservation is another very, very interesting and very interesting thing. The Supreme Court has always equated, the Constitution talks about class, reservation and OBC. I don't know whether the other backward classes, that's the word which it uses. But you interpreted OBC to mean castes. And that is I haven't come to a 1960 judgment which says that. And then very famously, Indra Sawhney, very famously quoting, I think, approximate what Ram Manohar Lohia ji said, the caste is class in India. So in many ways, you completely internalize the document, making it mean very different from what it actually said. So if I were to say, and with this I'll end, if I were to say that you started off with a liberal democratic constitution, you actually then worked it towards a cultural constitution. And going back to Sabrimala, that's the struggle which we are going to face in constitutional law. In Sabrimala, there were two judgments. There was a famous main judgment of Justice Chandrachud, and there was a dissent of Justice Indu Malhotra. Justice Chandrachud was obviously classic liberal democratic constitutionalism. And Justice Indu Malhotra, whose dissent was extremely brave dissent, and She wrote extensively about how this constitution does not come in a vacuum, how it comes in context of culture. And that's the cultural constitutionalism line. We are a huge society, so if you're going to interpret the constitution, you have to interpret it in context of our 5,000-year-old culture. That's the ethos which also I think in some ways the UK constitution has, because this entire concept of basic structure, this entire concept of American constitutionalism was not in the minds of our constitutional framers when they framed the constitution. If they were inspired for any other sort of format of constitutionalism, it was some sort of the post-19th and 20th century British constitutionalism, which the British were bringing in across the Commonwealth. So I think that's the struggle for the future between those who want to Americanize our constitution, including bringing in very strict basic structure, and those who want to bring in flexibility into the constitution and interpret it in context of today's world, which is Indian constitutionalism. Thank you.
I'll now request Swapan, a former member of parliament, well-known columnist, and now the distinguished fellow of India Foundation, to make his comments.
Thank you very much, Alok. First, let me compliment Ram Madhav ji on writing a slim but a very difficult book. I was describing this to Vikramjit. He said, if you and I were to write about the Constitution, would we have escaped controversy? Going by Vikramjit's own contribution just now, it's clearly not. But Ram's very deft maneuvering reminds me, maybe if I was to upturn a saying which was attributed to Muhammad Ali, which is, I would say, he stings like a butterfly, but he floats like a bee. So the kindness which he reserves for a lot of people who doesn't deserve the kindness is something which is, I think, admirable and exemplary. Let me start off with something else, perhaps being a bit nasty to not intentionally, to a very junior colleague who introduced this thing, Arpan, who's there. He said, the Constitution is not merely a legal document, but a moral one. Now that really struck me. I had grown up in an environment where I think when we were being taught the Constitution in our sort of third year of our BA history course, we were told it's a political document. Yeah, third year. Bharatiya has corrected me. We were told it's a political document. Now, clearly, Constitution belongs to the legal fraternity. It's like almost like you start a development, you create a massive development, run it for 20 years, and then hand it over to the legal fraternity to run it according to their wishes, with their embellishments, etc., etc. And you, once in a while, chip in with an odd contribution, suggestion, etc. This is what is basically the story of the Indian Constitution. I think Upendra Bakshi was probably not exaggerating when he said, in the context of the Keshavanand Bharati case, that we have presented India with a second constitution. So that there is a constitution, or there is a constitutional law, constitutional precedent, practice, etc., which predated that, and something which postdated that. I think this is very visible if you see some of the debates in Parliament. I recall the debate on Article 370, which was introduced in the Rajya Sabha. And the constant refrain from very senior legal luminaries like Mr. Chidambaram and Mr. Sibal was, You can pass anything you feel like, it'll never be approved by the Supreme Court. In other words, parliamentarians themselves, and they often quote, this is the judgment which was given in this case, that case, etc. That's become a habit. In other words, the onus of decision making has passed from the legislature to the judiciary. You're awaiting the approval of the judiciary to determine what constitutes the Constitution. But look at it in another way. Look at the two very landmark cases. I'm not a lawyer and I look upon it purely in political terms. Take two landmark cases in India, which have really defined this whole power balance. Take the Golaknath case. It was passed. The majority judgment was, if I'm not mistaken, 6-5. And take the Keshavanand Bharati case. Again, majority 7-6. In other words, if one judge hadn't fought with someone that evening, it could well have been the other way around. So what we are talking about in a more serious way is that this, if it was law, there would have been a degree of certitude. And I think that's the point about it. Where was the certitude? If it's 7-5, or 7-6, 5-6, or whatever the division was at that particular time. So to first say that this constitutes the law because the judiciary has deemed it, should be modified into saying that this was the prevailing wisdom of the judges at one particular time. We are talking about context. There is always a context. For instance, the earlier debates which took place on the Constitution, where there was a tussle with the judiciary, was all about this question of compensation. Land reforms, compensation. That was all the 50s and 60s was all about that. Nehru's great fight with the judges at times. Not really fight, but some sort of a strained relationship. That's gone out of the window now. We hardly ever fight about compensation. That's determined by other factors. There have been a multitude of tribunals which have set up for enhancing the employment of the judiciary. And they are the ones who decide on these things. Now, the question of the basic structure, which is really what the whole thing is. In other words, what is the meaning of the basic structure rulings at a particular point? It means that the final word on what should or shouldn't be done belongs to the judiciary. Who decides what is the basic structure? Is it the Constitution? The Constitution does not, so far as I recall, have a particular clause called the basic structure. You can take the preamble to be one. You can take the spirit of the Constitution. You can take the morality of the Constitution to mean the basic structure. Take the example of secularism, which was injected into the Constitution in a very illegitimate way at the time when Parliament had lost its, had run out of its mandate in 1976. The entire conflict over secularism has been post its injection into the preamble. It's not that prior to 1976, India wasn't a secular republic. We had secularism. We practiced it. But we didn't try to codify it. We left it to something called common sense, good approaches, how we looked at the past, etc. What Vikramjit was talking about. The moment you start codifying it, you create problems. In other words, then you get to this thing about the Bombay judgment, which everybody... It's good in one respect because you've set up certain parameters on how governments should not be arbitrarily dismissed. I think that's a good step. But at the same time, Bombay judgment also says that the so-called breakdown of secularism is a cause for a dismissal of a government. In other words, a central government can actually certify when you've broken the basic structure. So it's all sorts of muddle there. As it is, most people who try to understand Supreme Court judgments will find reading the Keshavnand Bharati, the 11 or 12 different things, completely, it's a Mad Hatter's party. Because there is no consistency, there is no singular thought, there are multitude of views and opinions which have been merged in, and yet this has been given to us as the final word, as this is the new constitutional morality, this is how the basic structure should be. So, in the 75th year of our constitution, we are afraid. The political class has gone into a complete retreat because they don't want to retreat. If they do, what happens? Then you're told that the basic structure decrees that consent and concurrence mean the same thing, as happened in the National Judicial Appointments thing. Apart from an assault on the English language, it also constitutes an assault on what we call common sense. Whether this is the parameter, the pillars on which constitutional morality can be built is something which we need to do. So for example, in the Nas Foundation case, that was a very interesting one. Maybe the conclusions of the judges were very sort of modern and with the prevailing trend. But it was not backed up with a single logic which was dated, which belonged to India. It was entirely a judgment which, as Vikramjit pointed out, drew entirely on foreign sources. And this is half the problem about Indian jurisprudence today. That we are being guided into an arena of politics where, number one, we treat 1950 as the year zero, suggesting there's nothing before it or after it, or not after it, before it. The Prime Minister referred to it in his speech, which Ram Madhav has quoted in this book, on the 75th year of our constitution, that India did not start in 1947. India did not start in 1950 either. There is a prehistory. If you want to be very generous, you can say secularism the modern notion of secularism can be traced back to the Crown Proclamation of 1858. You could argue that. I can make a very persuasive case to that effect. So the point really is, at various points, we need to have a degree of flexibility in the Constitution, whereby there is an engagement between various stakeholders and a negation of the belief that the judiciary has the monopoly of the truth. It doesn't. I'm tempted to quote from the Reith lectures, where a Supreme Court judge of the United Kingdom, Jonathan Scrumpton, who I came across partly because he's a very accomplished historian of the Middle Ages, I just want to conclude by just reading out what he said. If I might change my glasses because what constitutes majoritarian tyranny very much depends on how you define your minority and what you regard as tyranny. Except perhaps in classic discrimination cases where the animating principle is to treat like cases alike, there are no legal standards by which these questions can be answered. This is a man who was a Supreme Court judge in the United Kingdom. The only available standards are political. Experience suggests that judges charged with making essentially political decisions are no more likely than politicians to make enlightened ones. I leave that thought with you. Thank you.
Thank you, Swapanda. I think you'll all appreciate that there are differing views that we have heard from all our discussants. And in fact, Constitution has had its critiques right from the beginning. In fact, the drafting committee itself was criticized by Mr. Naziruddin Ahmad, who was actually a Muslim League member. And that also is an interesting trait, that 73 members of the Muslim League were in the original 389-member Constituent Assembly. And when they decided to boycott the Constituent Assembly to press for their demand for Pakistan, 28 out of those 73 refused to quit their seats and continued in the Constituent Assembly. And one of them was this chap, Mr. Naziruddin Ahmad, who was a fierce critique, saying that this drafting committee is nothing but a drifting committee. So there have been criticism. Now the floor is open for questions, comments on discussion, but please be brief because we've had a busy day. Okay. Okay. I just saw him first, so we'll just give him and then we'll just come back to you. Yeah. Next here. Just give it to General Katoch after that. Yeah. You.
Me?
Yeah.
Yeah, Madhavji, we are talking about morality, and written word is less moral than word of mouth. If you go by Ram Rajya, Dasgupta gave a word to Kekai, and that was much more respectable than, and same is UK constitution, which is unwritten. So do you think it was discussed of unwritten constitution also?
Okay. Yeah, we'll take a few more questions. Yeah, General Katoch here. Yeah.
My question is to Mr. Banerjee. When a constitution amendment is made with an authority that does not have the power to do so, I'm talking in 1976, how is it that those acts which were passed by Indira Gandhi's cabinet in the emergency, how can they be valid?
Bhaswati.
I just wanted to also pose a question to Mr. Banerjee and to Swapan with regard to the addition of the word secularism, and to agree with them when they said that the problem in today's constitution is that it has introduced Western concepts without taking into account the Indian version. When here the word secularism in the West is the complete separation of the state from the church after the French Revolution of 1789, whereas in India, secularism, before it was introduced in the constitution, meant tolerance and harmony among different people of different religious faiths. So similarly, there are many other such concepts in our constitution. So what is the way forward? Should we amend it further to remove these concepts? Or should we have a text which explains the constitution in its cultural concept, in its Indian concept, and in its understanding by normal Indians of what the constitution means? That's what
General Shukla.
I just wanted to ask anybody on the panel,
Was the chief aim of constitutional morality to prevent any organ of the state from declaring that it could uniquely represent the people? I'd underline the word uniquely. And I, want to pose this in the context of what's happening in the USA, when you have a government which has come to power with a strong majority. And it is in a live context where the chairman of the Joint Chiefs of Staff there, General Milley, took some stands in Trump 1.0. Everybody said he upheld the Constitution. Here comes Trump, and now he's being some talk of court-martialing him for the same issues, because Trump says he has got the brute majority of 80 million people. So without the judiciary being dragged in, how do you resolve these issues, where you say on the back of your vote, you can do anything?
Yeah.
Thank you,
Just
sir.
identify yourself and then.
Namaste, I am Tejasvi. I am currently a doctoral fellow at OP Jindal Global University and with CCCS as a consultant. I am privileged to be asking a question to a panel, I think, who has as many years of experience as my age. It's a very simple question. I come from international relations, but holds true for most disciplines. Does the Constitution lead the nation? And by that, I mean the people. Or is it the people that lead the Constitution? There's so much that's been talked about the cultural identification and contextualization of the Constitution. And I think it holds true in all domains, in terms of security, in terms of rights. So anybody on the panel could help us with that. Thank you.
Yeah. Comb Carpenter.
Thank you. My question is primarily to Mr. Shekhar Gupta. He asked why the 10 fundamental duties had not been removed from the Constitution given the circumstances in which they were adopted. Now, it seems to me, having been at some point involved in the discussions that took place with my father when this was done, and I remember that a number of luminaries of the government, including Mrs. Gandhi, said, if we put secularism in, then we should have dharma in some way, which is not regarded as culturally connected to a particular religion. Therefore, the 10 duties would in effect bring dharma in through the back door. Now, why would you want to remove this? It seems to me that it was an attempt to restore part of the Indian traditional spirit that Mahatma Gandhi so often referred to in the Constitution. Thank you.
I'll now request the panel to respond to them. We'll take the next round if we have time. I'll go in reverse order, starting with Swapan, please.
Yeah, firstly, I mean, this doctrine of permanence, which is really what the basic structure debate really suggests, that there are certain unending, abiding values which can never be changed. That's the essence of the whole debate. And to my mind, that's a very rigid way of looking at it. It's something which stemmed from Germany at one time, because Germans had their own little battles with history to fight, and they evolved this sort of a way out. And there was a very interesting question which General Shukla asked about this question of the brute majority. Now, you have one which is being enacted in the United States. You have another very different type of thing which is being enacted in Israel, for instance, where the government's decision to sack the chief of the Shin Bet, which is the main intelligence agency, and their advocate general is being resisted by the courts because they said that the government of the day has no right to choose or select them. And the chief of the Shin Bet, who's been sacked, insists that he will only go if he is allowed to choose his own successor. I mean, you can have that sort of a constitutional stalemate also there. So the idea, therefore, if we go into these doctrinaire issues of taking checks and balances to a ridiculous extreme, we are likely to get that. And I think in India, we need to find a way out. For instance, on the question of the appointment of judges, there's a complete stalemate. And this stalemate has to go. You cannot have a judiciary striking down a unanimous resolution of both houses of parliament, unanimous, on the grounds that, concurrence and consent involves the same thing. So if the constitution is to move from 75 years to 100 years smoothly, I think many more adjustments will have to be made, which takes into account certain contemporary realities and a hefty dose of good common sense.
Okay, I'll answer two questions together. I'll answer two questions together. One is people leading the constitution, constitution leading the people, and the question of majoritarian rule together. I'll address that. I think there's a wonderful sort of book by Lord Sumption, whom Swapan quoted, who was a former justice of the UK Supreme Court, where he says the tendency today is to remove more and more decisions which should ideally have been resolved in the political sphere and transfer it into a judicial sphere which is beyond debate. He says that is something which is a slippery slope, and that is not something which we should go down to. I think that's a debate which is being played all over the world, and this is a time of our times where we are thinking that maybe the people should not be allowed to debate this. I think it should play out in the political sphere. The two other questions, as for the 42nd Amendment, which was passed without a which was in some sort of an illegitimate, because the government had run out of its term. But I think the 44th Amendment took back a large number of amendments of the 42nd Amendment, which is the ones which introduce secularism, socialism, etc., but kept these provisions. So if you had to interpret it sub silentio, so it was a conscious choice when 44th happened that you kept the 42nd intact. Supreme Court has upheld that. And the last one is how do you do? I think the best way is what the Supreme Court has been doing, is indigenizing those terms. And that goes back to what Mr. Carpentier said, is the Supreme Court defines secularism as ekam sat vipra bahuda vadanti, in terms of, and ekam sat vipra bahuda vadanti, as Swami Vivekananda very specifically said, is the keystone of the, this is his words, keystone of the arch of understanding India. So in some ways, they've been doing that. They've been trying to Indianize it, and that's the only way forward. There is no other way forward.
I am among people who've done a lot more reading than me. I speak from a little bit of experience. And Shukla, since you mentioned about brute majority, I think Trump will get shown up in the course of time. This is very early days. Because everywhere, nobody gets 100% votes, right? So Trump will get shown up if he continues like this. And what he's done to General Miley, for example, I am sure a lot of people in the US armed forces are seething. As they are seething, looking at this, can you imagine one of those, I will not name anybody or hint at anybody, but you have a couple of these people who are short service commissioned officers from Indian Army, who now sit on TV channels, एक बार ठोक दूंगा पाकिस्तान को, मैंने जाके मार दिया, एक दिन में, 2 दिन में खत्म हो जाएगा, एक दिन में D+ सक्कर बराज, हाँ 2 दिन में D+ कराची, ऐसे बोलते हैं ना लोग. उनमें से एक को आप डिफेंस मिनिस्टर बना दें इंडिया को, हाँ, और उसको आप ऑपरेशंस करने की पूरी आज़ादी, हमारे तो डिफेंस मिनिस्टर ऑपरेशंस रन नहीं करते हैं, पर उसको ऑपरेशंस रन करने की आज़ादी दे दो, और वो फिर उसको सिग्नल पे सबके साथ शेयर करे, और उनमें अपने एनवायरनमेंट के एडिटर्स के साथ तो शेयर कर ले, लेकिन साथ में कोई एक सेकुलर लिबरल टाइप मेरे जैसे के साथ भी शेयर कर ले, है ना, और मैं उसको ट्वीट करूं कि अरे ये सरकार इतना बड़ा ऑपरेशन प्लान कर रही है, इस कंट्री के ऊपर बॉम्बिंग कर रही है, इन्होंने मेरे को भी इस पार्ट ग्रुप का बना दिया. वो देखिए उसका एटलांटिक का एडिटर का जो आज ट्वीट है, उसके करीब 20,000 रीट्वीट्स हो गए. वो एटलांटिक है, एटलांटिक इज लिबरल ऑफ द लिबरल्स, राइट. मतलब आप तो ये नहीं है कि these things will not have a blowback, there will be a blowback at some point. Second, this whole idea of majority. मैं आपको बहुत संक्षिप्त में कहानी सुनाता हूँ कि जब एक बार नवाज शरीफ 2/3 मेजॉरिटी लेके आया, ये बात है करीब 98 की बात है, 98-99, जब 2/3 मेजॉरिटी लेके आया तो उसने पहले आते ही अपने नेवी चीफ को फायर किया, उसके बाकी चीफ से भी लड़ाई शुरू हो गई थी और जजेस से भी लड़ाई शुरू हो गई थी। तो उसने कहा कि शेखर साहब मुझे एक बात बताएं कि आपके यहाँ भी जुडिशरी इतना इंटरफेयर करती जितना मेरे यहाँ करती है। तो मैंने कहा जी क्या मतलब आपका, ये रिकॉर्ड मतलब छपी हुई बातें बता रहा हूँ। तो मैंने कहा क्या मतलब, कहता है मैंने नेवी चीफ वाले को डिसमिस किया, बहुत समझता था अपने आप को, मैंने निकाल दिया, तो ये कोर्ट ने जाके रोक दिया, रोक रहे हैं, इंटरफेयर कर रहे हैं, आपके यहाँ भी करते हैं। तो मैंने कहा जी कोर्ट का तो काम होता है वो आपको, लेकिन मेरी अक्सरियत का क्या फ़ायदा है, मेजॉरिटी 2/3। मैंने कहा जी वो ठीक है, लेकिन ये जमहूरियत है, जमहूरियत में जो इंस्टीट्यूशंस होते हैं ये हमारे माँ बाप होते हैं, तो और ये हमें मेजॉरिटेरियन एक्सेस से बचाते हैं। नहीं नहीं, ये आपको बात समझ नहीं, आप पॉलिटिक्स नहीं जानते हो। तो मैंने कहा जी आप अब क्या करोगे इन जजेस के, मैं हटा दूंगा सबको। कहा हटा के क्या करोगे, मैं अपने लाऊंगा। मैंने कहा जी आप अपने लाओगे तो आपको जब अगले जनरल साहब आएंगे ना, और आप जब 111 ब्रिगेड आएगी और आपसे बोलेगी कि आप चलिए, और आप इन्हीं जजेस के पास जाएंगे, तो वो क्या करेंगे, वो तो मेरे जज होंगे। मैंने कहा जो आपके जज नहीं होंगे, वो उसके जज होंगे जो उस टाइम पावर में आएगा। आपको पता है क्या हुआ, अगले साल मुशर्रफ का कू हुआ, सेम जजेस टर्न्ड ऑन नरसिम्हा राव, नवाज शरीफ, सॉरी फ्रॉइडियन स्लिप, they turned on Nawaz Sharif. He went to jail, then he went to exile, finally he was in Saudi Arabia. एक दोपहर को मुझे फ़ोन आया, कोई डबल सम अनफेमिलियर कोड के साथ, तो उस ज़माने में उठा भी लिया करते थे, तब ये स्पैम नहीं होता था, मैंने उठा लिया। तो उसका शेख साहब मैं नवाज शरीफ बोल रहा हूँ, तो वो सऊदी अरेबिया का नंबर था। मैंने कहा जी बताएं कैसे हैं आप, कहाँ हैं, तो मैं सऊदी अरेबिया में हूँ, और मैं जो आपकी मेरी बात हुई थी बहुत सोचता हूँ उसके बारे में। तो आपने बोला था कि ये इंस्टीट्यूशंस का ध्यान रखना चाहिए और जुडिशरी का। अब ना जब मैं वापस आऊँगा तो अपनी जुडिशरी के लिए लड़ूंगा और मैं कभी उसके साथ इंटरफेयर नहीं करूँगा। अब देखिए पाकिस्तान, हाउ डिड मुशर्रफ लूज पावर इन 2007, ही फॉट विद हिज जजेस, ही सेड मेरी इतनी बड़ी मेजॉरिटी है, 97% कितना वोट तो मिल ही आता है, मतलब I'd like to meet the 3% who don't vote for these guys। तो उसने कहा मैं जजेस को निकालूंगा, लड़ाई हो गई, पब्लिक में प्रोटेस्ट हुई, नवाज शरीफ केम बैक फ्रॉम एग्जाइल एंड जॉइंड दोज प्रोटेस्ट। तो ये बातें, पीपल लर्न दीज लेसन्स द हार्ड वे, एंड दीज आर द सेफ्टी वाल्व्स in a democracy. So I think that is what I will say. And there was one question from there, sir, if they remove the whole thing, which means if they remove the fundamental duties, but also remove secularism and socialism, then there is no need, then it squares off. If you say that duties were put in to give the dharma aspect of secularism, right, तो उसको भी हटा दो, इसको भी हटा दो, लेकिन साथ साथ में there is another Western value which has been brought into the Constitution, which is socialism. Why don't you remove that also? The fact is that our next generation, I mean, my next generation, many of you are young, will be sitting here and debating this, and secularism and socialism will still be in the preamble of the Constitution, because really our national ideology is hypocrisy, right? National ideology is hypocrisy. You know, Sitaram Kesri once said, when he went to China, he said, जो चीन के कम्युनिस्ट हैं ये DTC के बस ड्राइवर जैसे हैं। क्यों चाचा, क्या मतलब? कहता है वो लेफ्ट सिग्नल करते हैं, राइट मुड़ते हैं, राइट? So our country is like that also. So this will remain there. Secular and socialist will remain there.
One outstanding issue that needs to be definitely thrashed out is about the definition of the basic structure. Almost all the speakers have highlighted. Once that is achieved, whenever it happens, I don't know, not left to the judiciary alone. Basic structures today doesn't have any clear definition. Courts can give different interpretations to it. Half a dozen to a dozen things can form the basic structure, including secularism and socialism.
Yeah,
that is also a basic structure now, according to the Supreme Court. So once we decide about basic structure and decide that that is the constitutional morality, upholding it is the constitutional morality. When the Constitution was drafted, there was a a kind of an understanding. That's why the constitution was arranged in that manner. First was national unity. One of the very fundamentals of our constitution is national unity. Our constitution begins with the statement, we the people of India. Another matter, people like us have a view that, in fact, it happened in the Constituent Assembly also, that people questioned Ambedkar, why are you copying this sentence from American Constitution? Because US Constitution begins with the statement, we the people of the United States of America. We justly borrowed it and adopted it as the first sentence of our Constitution. Members ask him, why don't you say, we the nation of India? Why we the people of India? Very interestingly, India is defined in Article 1 as Union of States. कोई मैथमेटिक्स टीचर है तो वो बताएगा, we the people of India are the Union of States. India is Union of States. India is nation. वो शब्द नहीं है. ठीक है, that's another debate. We don't have to really उतना डीप जाने की जरूरत नहीं, but basically national unity remained the first part of our constitution. The basic structure का first component should be national unity. Second important thing should be separation of powers. It's a political document, undoubtedly, as Swapan said. It's a political document. So we have to clearly have a clear separation of powers. When I say separation of powers, only not among the three organs of the state, like legislature, judiciary, and bureaucracy. Not just three, but also state, center, state, and now we have created third and fourth unit also. Under 73rd, 74th Amendment. So, clear separation of powers is second important thing. Second important thing is democracy. There should not be any doubt about it. One man, one vote is what we decided to adopt, and Ambedkar justified it, saying that it's, as somebody mentioned it, it's not something that we are borrowing from the West. It is there in our blood. This is what Ambedkar says in the Constituent Assembly. It is there in our blood. Democracy is in our blood. Then he gives the example of the Buddhist Sanghas. Deen Dayal Upadhyaya gives the example of the Samitis. So democracy as one man, one vote is something that we accepted as early as in 1919. So उस समय से हमने मान लिया था. But एक ही चीज ध्यान रखना है. What Gandhi used to say was that democracy for India should mean slightly different. Coming to Vikram's point, that you have to slightly Indianize these concepts. Democracy for India should mean that the weakest shall have as much power as the strongest, or as strong a voice as the strongest. That kind of a democracy you need to build. Deen Dayal used to say that democracy as one man, one vote should be until you win the elections. Once you win the elections, the formula should be building consensus. That kind of democracy we have to implement, not by majority in the house of the members present. That's the logic, na? आज एक बिल पास होना है, हाउस में 30 मेंबर है, 16 यस कह दिया, बिल पास होता है. हाउस स्ट्रेंथ is 542. Not that, building larger consensus. And then third, as I said, separation of power. And fourth is fundamental freedoms, not rights. Rights or duty discourse is a very different discourse. Certain fundamental freedoms should be ensured for people. So if these kind of things can be accepted as basic structure, on that basic structure, we commit, the whole nation commits itself to these 4 or 5 things. There can be 5th or 6th thing, but then that becomes the constitutional morality for the country. I excluded, as all of them said, secularism. Secularism was inserted, secularism and socialism were inserted into our constitution in 76 through 42nd Amendment. Everybody knows about it. But not many people know that there was a debate over it in Constituent Assembly.
And Ambedkar objected to this.
Swapan may excuse me, because he may say, I'm giving credit to people who don't deserve. Nehru opposes it. Nehru says, no, you will be confusing the people of the country by, inserting this word secularism in the constitution. The line is very thin in India between secular practices and, cultural practices. So don't confuse people. We don't need it. We are anyway secular. This was the spirit that they followed. That's why they did not include it. So why should we have it as basic structure? We are not against secularism. As ma'am said, secularism meant different things to different people. By the way, today in global understanding, there is no one definition of secularism. French secularism is very clear separation. You cannot have anything to do with religion. If you are a state subject, you cannot have anything to do with it. But British secularism is different. There, the king has to be always an Anglican. Nobody else can become the monarch, to king or queen. It has to be Anglican. And you go to US, the president takes oath by placing his hand on Bible, a bishop is standing there. Do you mean to say they are not secular? They are secular. There is different meaning. For India, as pointed out, it should be probably Sarva Pantha Samadhar, equal respect to all, not equality of all. Obviously, not all religions will be equal, but equal respect to all. So, certain things we have to Indianize definitely, but please remember that basic structure definition has not happened. That is a very big thing that probably we have to achieve in the near future.
Can I just steal 1 minute from you? Half a minute. That constitution, we have to be very careful about what we mess with, because nothing looks perfect, and sometimes when any government has a lot of power, you think I can do something more perfect. Look at your neighbors, the two countries which were created out of India, Pakistan and Bangladesh. Both have been, anybody who comes to power brings his own constitution, because they think I can bring a better constitution. As we speak, just 5 months back, Pakistan burnt up its constitution through a series of midnight amendments at 3 o'clock, 4 o'clock, right? They finished their constitution. Now the chief, General Sahab in Pakistan can serve 6 years, 9 years for life, right? Bangladesh is writing a new constitution. In fact, since 71, Bangladesh has had as many constitutions as Pakistan has had since 1971. So democratic, we say constitutional morality, but constitutional patience is also a very important virtue.
Thank you. I think we have no more time for any more round of questions, and I'd like to thank the author and the discussants for taking time out from their extremely busy schedule. You'll appreciate all three of them are extremely busy, and they were kind enough and gracious enough to give us time. And I'm also extremely grateful to all of you for taking time out from your busy schedule. We had a house full with people standing, and I apologize for people who are standing behind because the hall has a limited capacity. I'd also like to thank India Habitat Center for helping us as always. We in India Foundation always organize 2 events every month, and our next event is on 7th April, which we'll be discussing the book by Sachin Nanda on Dr. Hegdewar, his definitive biography. We'll be discussing on 7th April. So please do come, same time, same place. Looking forward to it.